speak now about Dave Nahmias, who is United States Attorney for the Northern District of Georgia in the United States. David Nahmias attended Duke University, where he graduated second in his class and summa cum laude, and Harvard Law School, where he graduated magna cum laude and was the editor of the Harvard Law Review. Dave joined the United States Attorney's Office in Atlanta in January 1995. He handled a variety of violent crime cases and worked extensively on the investigation of the Centennial Olympic Park and subsequent bombings that resulted in the indictment and ultimate conviction of Eric Robert Rudolph. Dave then moved to the Fraud and Public Corruption section, where he successfully prosecuted a Georgia state senator and worked on a major investigation of corruption in the city of Atlanta and Fulton County governments. A few weeks after the terrorist attacks of September 11, 2001, Dave was detailed to the department's criminal division in Washington, where he coordinated the investigations and prosecutions of Al-Qaeda and other terrorist activity around the country and the world, and assisted in counterterrorism policymaking. After being nominated by the President and confirmed by the Senate, Dave returned home to Atlanta as the United States Attorney to the Northern District of Georgia. He serves as the Chief Federal Law Enforcement Officer in the district and manages an office with approximately 80 lawyers who represent the United States in all criminal and civil litigation at federal courts in the district. Dave also serves as on the Attorney General's Advisory Committee of the United States Attorneys, which recommends policies for federal prosecutors nationwide, and has chaired that group's subcommittees on terrorism and national security and on white-collar crime. Dave.
I appreciate the invitation to participate in this important conference. I've never been a speaker between a baroness and a congressperson, and so I'll do my best. I am more like Michelle. I'm a nuts and bolts practitioner and want to talk to you some about policies that I've had some role in implementing or watching, and then the efforts to apply those policies in the field in an effort to protect my community and other communities around the world and around my country. The main issue I want to talk about is the phrase, the balance between national security and civil liberties, or between security and human rights, which is a phrase that's been used some at this conference and is used almost anywhere people talk about counterterrorism, whether seriously or in the popular culture. It's often a phrase used with little thought about what it really means or about how the balance should best be struck, even though that balance between security and liberty is fundamental to the long-term preservation of both our security and our liberty when we confront the threats of global and local terrorism. None of the points I will talk about are probably novel to you, but I hope some of them will serve as reminders as you think and talk about these issues and debate them both here at this conference the remainder of the week and in your work when you return home. I want to begin with the fundamental point that in democracies it always is a balance between national security and individual liberty or rights. We often say that, but in the debates over this issue, sometimes when that phrase is presented, we must talk about the balance between security and liberty or security and rights. It's meant to end the debate by invoking the magical phrase fundamental rights or human rights or civil liberties without any real probing of the issue. And that's not a very helpful approach. To begin with, many times the law doesn't, in fact, when probed, protect the civil liberty or human right asserted, making the debate really one about policy and not of legal requirement. In addition, we have to determine to what extent the asserted liberty will, in fact, be affected or impaired by the government action at issue, and then whether the interests on the security side of the balance justify the limitation. We also have to consider, however, that the explicit recognition of the civil liberty at issue may often, in the larger struggle to win hearts and minds, have a real affirmative value. But without careful testing of the interests on both sides of the balance, without using shorthand to try to end the debate, we won't reach the right balance. I want to focus on 2 points on the security side of the balance. The first involves the need to pay more attention to the terrorist attacks that were seriously planned but did not occur, or that occurred but did not produce the catastrophic results that were intended and possible. Most of us, and I believe almost all people in the public generally, tend not to pay sufficient attention and therefore give sufficient weight to terrorist threats that exist but don't come to pass, whether that result is due to good intelligence or police or military work, or, as Michelle said, simply very good fortune. This failing is in large part because the news media and our political systems don't pay nearly as much attention to catastrophic events that don't happen, because it's hard to write and broadcast stories, and it's hard to hold interesting hearings about such non-events. I'll give you a few examples. The first World Trade Center bombing in 1993 was intended by Ramzi Youssef and his associates to kill tens of thousands of people. Had it done so, the American government and our people would have woken up to the potentially catastrophic dangers of Islamic extremist violence a decade earlier than we did. But the 1993 bombing killed only 6 people. An FBI agent at the scene later described that as a miracle. But as the 9/11 Commission later reported, the lack of those catastrophic results and the apparent ability to respond to the event through our traditional law enforcement system led to, quote, widespread underestimation of the threat. Likewise, in 1995, police in the Philippines rather fortuitously discovered and disrupted the Manila Air or Bajinka plot, in which Ramzi Youssef again, his uncle Khalid Sheikh Mohammed, and others were very far along in a plot to simultaneously blow up a dozen trans-Pacific airliners. Had that plot succeeded, America and the world would have focused on this catastrophic threat that Islamic extremist violence poses to civil aviation and innocent people, again, much earlier. That focus would have been driven by around-the-clock media attention for weeks, by government commissions, by government hearings. But because that plot was foiled, it became a sidelight. The topic of a little-noticed trial in New York, the threat understood by only a few, and the hunt for KSM relegated to a handful of FBI and CIA agents, leaving him out there to mastermind the 9/11 attacks. Unfortunately, as a general matter, I don't believe that 9/11 has fully changed this mindset. Had Richard Reed been successful in igniting his shoe bomb as his flight crossed the Atlantic just before Christmas in 2001, just 3 months after the 9/11 attacks, the fear generated would have been enormous, as would have been the economic damage, particularly to the commercial aviation industry, which was on the edge of solvency. But because Reed was unsuccessful, the event was downplayed and soon forgotten, leaving many travelers taking off their shoes in airport security lines to grumble about the burden being imposed on them by the government, having forgotten entirely about the concrete evidence of the threat their governments are trying to address. My final example is the more recent threat, again to transatlantic passenger flights disrupted in the United Kingdom in the summer of 2006. The trial of several of those terrorists occurred this year, and during that trial, many of the detailed elements of the plot were presented in open court, but it received virtually no media coverage in the American media. Again, because it's so easy to ignore the fact that thousands of people did not become innocent victims, many people complain about the restrictions that were imposed on their liberty as a result of that plot, but they haven't been fully exposed to the underlying information about the threat. And the split jury verdict that was returned yesterday is going to lead to even more disregard of that threat posed. I don't mean to say that every far-fetched terrorist plot deserves an overwhelming security response, but I do mean to say that if we only pay full attention and if we only respond fully to completed, successful, catastrophic attacks, we are not properly assessing the security side of the balance. I wonder what other foiled plots are out there that we are not understanding and integrating into our security plans. And this leads me to my second point about the security side of the balance. And this point can be difficult to accept for smart people who are heavily involved in counterterrorism issues. As we heard reiterated this morning, counterterrorism operations are all about intelligence. And I believe that those of us who do not have access to the most recent and comprehensive intelligence must give considerable deference to those who do have such information. This is not to say that the available intelligence is always complete or accurate or well analyzed. As we are all aware, and prominent commission reports have demonstrated, we have had repeated major intelligence failures in the United States over the past decade, and that is not an experience unique in the world. But nevertheless, decisions about national security and counterterrorism in particular must be based on the best intelligence available, and by its very nature, the best intelligence rarely can be shared in full context with the public without compromising the most sensitive and valuable human and technical sources. As a result, I believe that government assertions about security interests must be assessed with a degree of deference, or perhaps a better term is humility. I have had the experience of once having considerable access to high-level counterterrorism intelligence when I was in the front office at the Justice Department headquarters in Washington for the few years after 9/11, but then losing much of that detailed, day-to-day, compartmented access when I returned to the field. Even though I still have access to some classified information and I try to closely follow the open source reporting, I am repeatedly reminded that I do not know or fully understand the full nature of emerging plots and threats, both the ones that never become public and the full details of many of the plots that emerge to only a limited extent in the public realm. To repeat my first point, in part because the media and other reporting rarely focuses on those kinds of plots. Our current Attorney General, Michael Mukasey, had the same experience going in the opposite direction from me. As a federal judge, he had presided over major terrorism trials, and when he was appointed, he was considered by many to be an expert in terrorism issues. Yet he has often spoken about how once he had access to the most current intelligence as our Attorney General, he quickly realized just how much he had not known about the nature and extent of the threat. This point has special import when it comes to judicial review of counterterrorism policies. I do not question the importance of having independent judges have the final say on legal questions regarding counterterrorism policies. Indeed, that is fundamental to our conception of the rule of law. But we also have a long legal tradition in our country in which judges recognize that they are not well equipped institutionally to evaluate issues of intelligence, foreign policy, and other matters of national security. And so our courts have traditionally given broad deference to the executive's assessment of those issues. To the extent that deference is reduced, so too will be, in my view, the appropriate weight given to the national security side of the balance. I worry a lot about this trust issue, as does Professor Jack Goldsmith of Harvard in his recent excellent book, The Terror Presidency, where he writes, quote, "The terror presidency's most fundamental challenge is to establish adequate trust with the American people to enable the President to take the steps needed to fight an enemy the public does not see and in some respects cannot comprehend. This is an enormously difficult task," unquote. I agree it is enormously difficult, and it's made that much harder by the fact that we must affirmatively protect from public disclosure the very intelligent sources and methods and results that are essential to understanding the threat, but are also so essential on an ongoing basis to our efforts to identify and respond to significant threats. So on the national security side of the balance, I believe we must put considerable trust, however hard that may be, in those with access to the most information and to learn from the catastrophes that could well have occurred but did not. Now let me turn to a few observations on the civil liberties side of the balance. First, I believe it is imperative that we understand and distinguish between what is required by law, particularly the relevant nation's constitution and other fundamental law, and what is a matter of policy. In democratic societies, the law must of course be obeyed or changed through established and open processes. Policies are more dynamic, yet people trying to control the policy decision sometimes do so by asserting that the result is required by the law. This, in my view, warps the debate and can prevent reaching decisions, including important compromises, that best set the balance and that can be more readily adjusted as circumstances change. One example of this was the confusion about the FBI's so-called national security letters, or NSLs, which are essentially administrative subpoenas for several types of records. NSLs are commonly criticized, and efforts have been made to outlaw their use on the ground that they seek to obtain records, quote, without a search warrant. But the records at issue are almost always business records held by third parties like banks and telephone companies, and our constitutional law has been clear for decades that no warrant is needed to obtain such third-party records. Again, there are legitimate policy disputes about whether NSLs are a good idea and what limitations should be imposed upon them. But these are almost entirely questions of policy and not of constitutional law. My second point about the civil liberties side of the balance is that it is essential to recognize that protections of civil liberties are not costless. To the extent that cost is imposed by compliance with a nation's fundamental laws or international laws, that's a background cost that must be accepted. On this point, I note that it's somewhat ironic that many Western European nations have background laws that are much more liberal as to civil liberties protections than American law. For example, multi-week detention of criminal suspects without charges or conviction for offenses involving advocacy of terrorism or mere membership in a terrorist group are measures that American constitutional law clearly would not allow. Those nations have set the background balance in a different and more pro-security place. Our constitutional civil liberties protections prevent such measures. But beyond such fundamental rights, the cost of protecting civil liberties must be evaluated honestly and openly. I can't make this point better than Stuart Baker did in an article in December of 2003. Stuart Baker had been the general counsel of our national security agency, the NSA, from 1992 to 1994. And during the mid-90s, he strongly defended the so-called wall that prevented intelligence and law enforcement officials from working together on international terrorism investigations. In his article, he notes his defense of the wall, and he notes the findings of post-9/11 inquiries that it was the wall that prevented perhaps the best opportunity to identify the hijackers and save nearly 3,000 people from being murdered. Mr. Baker wrote that he had learned the following 3 lessons, which I'll quote at length. First, that the source of this tragedy was not wicked or uncaring officials. The wall was built by professionals who thought they were acting in the country's and their agency's best interests. They were focused on the hypothetical risk to privacy if foreign intelligence and domestic law enforcement were allowed to mix. And they worried that courts and Congress would punish them for putting aside these theoretical concerns to combat a threat that was both foreign and domestic. They feared that years of successful collaboration would end in disaster if the results of a single collaboration could be painted as a privacy scandal. So they created an ever higher wall to govern operations at the border between domestic law enforcement and foreign intelligence. As drafted, the rules technically allowed anti-terrorism investigators to do their jobs if the investigators were sufficiently determined and creative. For a while they were, but the Foreign Intelligence Surveillance Court scandal sapped their determination and finally choked off any practical hope of getting the job done. The second lesson is that we cannot write rules that will both protect us from every theoretical risk to privacy and still allow the government to protect us from terrorists. We cannot fine-tune the system to perfection because systems that ought to work can fail. That is why I'm profoundly skeptical of efforts to write new privacy rules and why I would rely instead on auditing for actual abuses. We should not again put American lives at risk for the sake of some speculative risk to our civil liberties. And the final lesson, perhaps it isn't fair to blame all the people who helped create the wall for the failures that occurred in August of 2001. No one knew then what the cost of building such a separation would be, but we should know now. We should know that we can't prevent every imaginable privacy abuse without hampering the fight against terror, that an appetite for privacy scandals hampers the fight against terror, and that the consequences of these actions will be more attacks and more dead, perhaps in numbers we can hardly fathom, unquote. Again, I cannot say it better. Civil liberties and human rights are undeniably an important benefit, not only in the freedom and dignity they protect directly, but in the example they set for people aspiring to freedom across the world. But their protection can also impose a real cost on efforts to preserve security. That cost may well be worth bearing, but the values and the costs must be assessed with clarity and honesty and not simply assumed or ignored. This leads to another observation, one also suggested by Stuart Baker. I believe that the focus of concerns on the civil liberties side of the balance should be on the potential and actual misuse of government power to intentionally target innocent individuals, particularly for political reasons. Such intentional abuses are at the core of the intelligence and law enforcement excesses in American history, as well as the abuses we have seen historically, continue to see in governments around the world. If an authority might be used, or even if it is actually used mistakenly against the wrong person, that's obviously a problem. But that can't be our standard in setting the balance, because anyone who's been around government understands that governments, which means, of course, the very human beings that constitute our governments, will make mistakes. Such unintended mistakes can often be remedied or limited through better training, supervision, and oversight. More importantly, there's a built-in disincentive to making mistakes because they are a waste of resources and time. The most serious threat to liberty comes from the intentional misuse of government power and the risks thereof to target political opponents or disfavored persons or groups, especially minority groups. Thus, for example, we have had a lot of debate in the United States about the FBI's violations of policies regarding the use of national security letters. But I have only moderate concerns about those violations. They appear to be, for the most part, large numbers of mistaken requests, bad record keeping, and the like, and the harm caused and the danger to liberty posed is therefore also limited. This isn't ideal, but I have not heard any evidence of concrete harm caused by these mistakes, and there are issues that can be resolved through better training and oversight. If, on the other hand, I saw evidence of intentional use of NSLs to target a political opponent or the like, then I believe more significant policy changes might be in order. In the absence of such evidence, proposals to abolish or greatly restrict national security letters are, in my view, a classic example of trying to prevent even a few errors at the cost of impairing a tool that is essential to gathering the most basic information needed to investigate potential threats to national security. It is also important to recognize that many of the means of identifying and deterring mistakes, as well as intentional abuses of authority, things we often talk about, more record keeping, more and higher levels of supervisory authority, more reporting to inspector generals or congressional committees or courts, sunset provisions. These are measures that have very real costs in a system operated by human beings. At the line level, line FBI agents, line police officers, line intelligence agents, when they are trying to decide what to do with yet another piece of information that seems to have a low likelihood of developing into a major investigation, who would then have to do a lot of paperwork or wait for supervisory approvals just to be able to gather basic information or conduct an initial investigation. Being human, they will often decide not to do that. And being human, by doing that, they will often miss the tip that could lead to breaking open a case that could save thousands of innocent people from being murdered. The bureaucratic costs of additional procedural protections on rights are often ignored or dismissed, but they need to be factored into the balance. And that brings me to my final point. As I consider the civil liberties side of the balance, as with the national security side, I believe we must place a significant level of trust in our government officials. I know that trust in government is considered passé. I understand that the system of government in my country, as well as many others, is based on the premise that government must be limited because power inherently corrupts. I share those views to a large extent. But I also recognize that government is composed of human beings, and for government to function, we must allow those officials to exercise the necessary power of government. To again use the example of national security letters, I've wondered about the amount and intensity of the concern expressed about this tool that requires FBI agents, who are typically the best trained and educated and among the most professional individuals in our law enforcement and intelligence world. These agents are required to complete extensive documentation and obtain multiple supervisory approvals to be able to obtain NSLs for third-party records with no constitutional privacy protection. On the other hand, I hear few concerns when we give guns and badges to 20-year-old police officers and authorize them to go out on the streets where our families live and make split-second decisions about whether to use deadly force against other citizens. Indeed, my Justice Department over the years has criminally prosecuted dozens of police officers for misusing that authority and misusing their weapons to violate the civil rights of individuals. But I hear no one seriously suggesting that we should therefore take away guns from all of the tens of thousands of police officers as we balance our community security against civil liberties. Instead, the remedies are better supervision, hiring, training, oversight, including criminal prosecution for serious and intentional violations. In his book, Professor Goldsmith recounts Secretary of War Henry Stinson's congressional testimony on the eve of America's entry into the Second World War about the very controversial but ultimately critically important Lend-Lease Act. Responding to concerns about placing so much authority in the hands of President Franklin Roosevelt, Stinson emphatically replied, quote, "Government or law which is based on the premise that you cannot trust anybody will not survive the test of war." I emphatically agree. Let me close by thanking you all for your attendance at this conference. These types of events are critical for sharing information and knowledge about setting this crucial balance between our liberty and our security. It is not a balance that is the same in all places or all times. I think it's most apparent for this place in which we are meeting, a nation that faces unique threats to security and also has a unique history of its people with regard to liberty and human rights. My hope is to develop more knowledge, objectivity, wisdom, and particularly more humility about these issues as we try to set the balance in the right place and contribute to the effort to both preserve liberty and preserve our security. Thank you.